Thank you guys for coming out today to support our debate. The Federalist Society is happy to present this and very gracious to our debaters. Professor John Fleshnick is going to be our moderator today, and we'll let him take it away.
Hello. I see great turnout from our Federalist Society, and I'm honored to serve as faculty advisor to you. But I also note that we have support here from the American Constitution Society, their president, and many of their members. So this is truly a bipartisan debate over one of the most significant cases to be decided in constitutional law in the last several decades. And we could have no two more qualified people to give both sides of this debate in Professor Josh Blackman of South Texas College of Law and our very own Professor Abby Moncrief of CSU College of Law. I want to briefly state their esteemed backgrounds. Professor Blackman has taught for 13 going on 14 years at South Texas. He has clerked for not one but two federal judges, Judge Boggs of the U.S. Court of Appeals for the Sixth Circuit and Judge Gibson of the U.S. District Court for the Western District of Pennsylvania. His publication list includes Georgetown and many others. It takes about 5 minutes to even scroll through full speed through his CV.
You can skip it.
So I won't. But nonetheless, he has been writing on these issues for many years, and we're very grateful for him to be joining the Federalist and ACS societies here today to share his perspective. Professor Moncrief needs no introduction, but she deserves one nonetheless, having taught at no less than Harvard, UPenn, one of my alma maters, NYU, University of Texas, Boston University, and St. John's. Of course, she holds her PhD in government from the University of Texas, in addition to her JD from Chicago and a BA from Wellesley College. Professor Blackman himself has a JD from George Mason and his BS with high distinction from Pennsylvania State. Each of our debaters will start with 10 minutes to make their case, followed by 5 minutes apiece, beginning with Professor Blackman. Sir, you have the floor.
Thank you so much. My first time at Cleveland State, thank you so much for having me. But I might disagree with the moderator. I don't think this case is that important, and I think I'll explain why. So first, let's start. What is immunity, right? There is a lot of immunity in the law. Have you studied qualified immunity, right? If you're a police officer and you engage in brutality, you may be immune unless there's some sort of clearly established law saying that you can't do X. Judges have immunity too. It's called absolute immunity. Good luck suing a judge. Prosecutors have absolute immunity also. Good luck suing them. What is the basis for immunity? I don't really know. A lot of courts have made up these doctrines over the year. They're unpopular, but they exist. There's another type of immunity that dates back to the time of Thomas Jefferson and John Marshall, which is called presidential immunity. This doctrine first arose in 1807. Aaron Burr, that guy who shot Alexander Hamilton, was being tried for treason. And Burr said, aha, I want some documents from President Jefferson that can help my defense. Jefferson said, go away. You can't issue a subpoena to me. And this case began the basis of what's called presidential immunity. That is, not all process from the courts can go against the president because he has a very important job. The basis of the immunity was frankly never well explained, but it was there. Fast forward to about 1973 with President Nixon and Watergate. What happened? The special prosecutor demanded certain documents from President Nixon, the White House recordings, the tapes in the Oval Office. Nixon said, no, I am not going to give you these documents. And the Supreme Court held in a very controversial opinion, stop it, Nixon, give the documents over. You have some immunity, but you can't resist giving evidence in a criminal trial. Okay, so that's U.S. v. Nixon, 1973. Fast forward about a decade to another Nixon case called Nixon against Fitzgerald. By this point, Nixon was out of office, but he was still sued. What was he sued for? Employment, right? Some sort of dumb employment dispute because he basically said something bad about a government employee and there was a lawsuit, right? Facts are not important. But what did the court hold in Nixon versus Fitzgerald? Quote, the president is entitled to absolute immunity from damages liability predicated on his official acts. Again, the president is entitled to absolute immunity from damages liability predicated on his official acts. So if the president's acting according to his official powers, then there's no civil liability. Again, that was a decision from the 80s. It is still good law. Let's jump ahead to the 1990s when I think none of you were actually born. In a case called Clinton against Jones, which Professor Moncrief and I do remember. This was a very big case at the time. Bill Clinton was a sitting president, and he was sued, but not for conduct while he was president. He was sued for his conduct while he was the governor of Arkansas. Paula Jones sued him for some sexual assault crimes. Okay? The question went to the Supreme Court. Can a sitting president be sued for conduct that came before he was in office? The court held that yes, he could be sued, that there's no immunity from his pre-presidential activity, and the lawsuit can go forward. And then Clinton settled the case and sort of went away very quietly. Okay? Let's go forward a little bit more. Trump comes to office, and we have lawsuits regarding his tax returns. Okay, there was one lawsuit brought, one case involved the the prosecutor in Manhattan. Another case involved the United States Senate seeking his tax returns for their Committee on Finance. This resulted in two cases that were kind of, not at odds, but just they kind of went a little bit different directions. But the court held that Trump had to deliver the tax returns to the prosecutor in New York, but there's some sort of a weird balancing test for the Senate committee, and that case fizzled out. But in other words, whatever immunity the president has under the Burr case, you have to put forward these documents. And again, these were Trump's returns from not his time in the office, but time before he became president. Okay. One more example, I'll get to the actual case topic in chief. Mueller, right? There were two Trump impeachments. Everyone remembers Ukraine was the first one, but there was also the Mueller investigation. Trump was charged with, or not charged, was alleged to have engaged in obstruction of justice. What was the obstruction? He fired the FBI director who was investigating Trump. I mean, most of us, if we're being investigated, we can't fire the prosecutor. Like, I don't have that power. She doesn't have the power. But when you're the president, he's got the power. But it was argued that his removal of the FBI director, Comey, was obstruction of justice. This never made it to court because Trump was never actually indicted. But the Mueller report suggested that had Trump been indicted, he would have been guilty of obstruction. But that sort of elided the question, was there immunity? Would the president be immune from this, assuming it was obstruction? All this is a way of background saying that there's some very unsettled issues about the scope of presidential immunity. Why is it unsettled? Because no president had ever been indicted for a felony. By the way, President Grant was arrested on charges of speeding in a horse and buggy. True story. He was given a ticket for speeding in a horse and buggy. Anyway, but no president had ever been charged with a felony. Okay, come to January 6th, we all know what happened. It was wild. President Trump was later indicted by Special Counsel Smith on charges, not of insurrection, but on something kind of more mundane, obstruction of official proceedings, obstruction of Congress. Okay, why does this matter? The conduct is alleged to have occurred during Trump's term in office. And Trump alleges, aha, I have absolute immunity. You can't prosecute me for this. The lower courts rejected the immunity claim and allowed the case to go forward. As you know, usually when you get a ruling against you, you have to sort of go to trial and then appeal it later. But immunity is different. You can take what's called an interlocutory. Remember this one? Interlocutory appeal straight up to resolve the immunity issue. Because look, if you're immune, you don't litigate it, right? You don't go to trial if you have an immunity. So the case goes to the Supreme Court, and the court splits. I'll say it was 6-3, but it was really more like 5-4. I'll get to that in a moment. But at least 6-3 or 5-4, depending on how you count, ruling in favor of Trump. Chief Justice Roberts writes the majority opinion. And he tries to do a lot of things. One thing he does, he says, look, we have this precedent, Nixon versus Fitzgerald, which says that there's absolute civil immunity. And he says, there's no reason to not apply to the criminal context. Indeed, Roberts says criminal is worse than civil, right? With civil, you might be able to settle it, pay some damages, make it go away. With criminal, you might go to jail. So if there is absolute immunity for civil suits, why wouldn't there be the same type of immunity for criminal litigation? That's what Roberts says. And then Roberts looks to Youngstown. Remember that case from who's here's taking con law? How far are we from Youngstown? We're pretty close, right? Right. By the way, I teach property Village of Euclid, right over here. By the way, if I could reverse any case in 20th century, it'd be Euclid. Worst case ever. Terrible decision. I live in Houston. We don't have zoning in Houston. Anyway. It's true. It's true. I would get rid of zoning in a minute. Okay. But Roberts looks to the Youngstown Sheet and Tube Company decision. This case, I know I have like 2 minutes left. This case established 3 zones of presidential power. Remember this? So that where Congress is acting with support of Congress is at its apex. That's probably illegal. And when Congress is acting, when the president's acting with his own powers only, in the lowest ebb, that's probably not going to cut it. But there's this middle fuzzy region where it's not clear what the president's powers are, and it's not clear what Congress's powers are. It's a zone of twilight, Jackson tells us. We don't really know. Okay, so Robert, he loves Robert Jackson, by the way. He has a picture on his wall. Roberts tries to basically copy Jackson, perhaps not the best way, but he has these 3 categories of conduct. Let me walk through them. In the first category, he says, where the president's exercising his core, that's it, the core powers, immunity is absolute. These powers are conclusive, exclusive. In other words, if there's something in the core of the president's powers, he cannot be criminally charged for that conduct. Why? Because the president's Article 2 powers trump, no pun intended, whatever statute Congress may have adopted. Okay, that's category number 1. Category, I'll skip to the bottom one. I'll come back to 2 in a minute. Category 3 is when the president's acting private or unofficial, right? There's no immunity. So the classic example you might give, Trump walks out of his office, goes to Fifth Avenue and shoots someone, right? That's not presidential. There's nothing there. Even Trump's lawyers agree that hypothetical would not be subject to immunity. But then there's the middle category, which is where everyone kind of went off the rails. Everyone agrees on 1 and 3. There's not much dispute there, I don't think. It's number 2 is where the big dispute arises. Roberts says for other official actions that are outside the core, he describes not a zone of twilight, but a presumptive immunity. And that's people get upset. There's a presumptive immunity for this middle category if it's within the outer perimeter of his official responsibility. So if it's like in the curtilage, if you will, in the curtilage of the president's powers, this is something that's within the president's immunity. Unless he puts a test, unless you can show that prosecuting this crime would intrude dangerously on the function of the executive branch. In other words, there's presumptive immunity even for this middle category, unless there's some good reason not to. Okay? Justice Barrett wrote a concurrence, and it's not clear to me she agrees with much of what Roberts wrote, but she for sure disagrees on 1 point in particular. Evidence. So what happens is, let's say, okay, we have immunity. You can't charge Trump with all this presidential conduct. But what happens if the prosecutor wants to introduce as evidence some of the immune conduct to convict him of something else? Majority says no go. You can't introduce as evidence. Barrett says, no, the rules of evidence will handle it. We'll just let the judge balance it out. So that's an area they disagree. But I don't know that Barrett even agrees with this 3-factor framework. She doesn't say so clearly. It's actually a very frustrating opinion. I've read it many times. I just don't really know what she thinks. Read the opinion. I don't know. But that's there. Okay, so what happened in the wake? Oh, sorry, and that's right. The dissents by Justice Jackson, Kagan, Sotomayor, and they say this puts the president above the law, and that this is. I'm sure she'll talk about the dissent in a moment. I want to rush through, but that this was a very dangerous decision. Okay, in the wake of the decision, Trump was re-indicted. That Jackson put forward a new indictment, which is being litigated as we speak. And what he did was basically took like some whiteout and just crossed some stuff out. You know what whiteout is? You know what whiteout is? No. He crossed stuff out, redline, if you will. He redlined the indictment.
He just deleted it in Word.
Yeah, he just, yeah. That's like whiteout. He just deleted stuff from the indictment, taken all the presidential stuff and then made it. And in my mind, this indictment probably sticks in large part. But this is sort of an ongoing issue. The district court judge in D.C. will probably decide this soon. And it might go back to the Supreme Court. But of course, I'll make this my last point. I'll sit down. We have an election coming up. I'm sure in Ohio you know about this election. In Texas we don't have really ads, but I'm sure you have to give ads nonstop. If Trump wins the election, 50-50 shot, he will likely fire the special counsel. He might pardon. We don't really know. This issue doesn't get resolved. If Trump loses, this will go to a final judgment soon. And indeed, in some regards, if he's out of office, it makes this easier to decide because it doesn't affect the outcome of the election. So for whatever you say, if Trump wins, we will probably not get a resolution of this issue. If Trump loses, we will not like the resolution. All right, a little bit over. Thank you so much. Let me sit down and have some time for rebuttal later. Thank you so much.
Professor Moncrief, I think you have 12 minutes.
I have 12 minutes?
Yes, you
Just
do.
in the
Yeah, I'm
interest of
sorry.
fairness?
Yeah, I'm
Yeah.
sorry about that.
Because Josh went over?
I'm sorry.
I'll just speed talk and only go for 5 minutes. Good luck following. All right, well, Josh did me the favor of having covered some of the opinion's content so that I actually get to critique it rather than just telling you what the what the justices did. So there's going to be some ground on which we agree, which is that there's a core of immunity that needs to be protected. So if a cop sees you committing a crime and you're running away and you have a weapon, the cop needs to be able to tackle you to the ground and put handcuffs on you without worrying that that cop is committing a crime of battery by tackling you to the ground and putting handcuffs on you, and without worrying that you're going to sue the cop for battery or injuries that you sustained during the course of that encounter, right? So like we need executive agents to have some amount of immunity for the official acts and public service acts that they engage in the course of being cops, being executive agents, because the nature of governance is coercive and violent. And when we talk about the things that we try to prevent among private actors, we want to prevent coercion and violence. When we talk about public actors, they need some scope of protected space in which they can engage in coercion and violence without fearing legal consequences imposed by the state. So the core of what everybody kind of agrees needs to be protected is some amount of immunity for official acts that protect against particularly civil liability, meaning money damages sued for by private citizens when executive agents are in office performing official acts. What's weird about the Trump case is that it presented two big differences between the core of what is everybody agrees needs to be protected. Criminal rather than civil liability for a president who is no longer in office and therefore doesn't need to be able to continue to engage in official acts without fear of consequences. So should those two matter? Should those two distinctions matter? Should we care that this is criminal instead of civil liability for a president who is no longer actively serving in office at the moment that the criminal charges are brought? The court says criminal liability is worse than civil liability and does not pay any attention to the in-office versus out-of-office distinction at all, except to say that if we allow criminal prosecutions for presidents, whether they're in office or out of office, we're going to open a Pandora's box of politically motivated prosecutions between the two political parties. So when Trump leaves office and Biden takes over, the Biden administration is just going to come up with a million different ways of putting Trump in jail. And then if Trump gets back in office while Biden's out of office, Trump's going to figure out a million different ways to put Biden in jail. And we're just going to live in this chaotic system of political retribution in which each party is going after the leader of the other party all the time. And so he has this very jaundiced view of how each president is going to use, each political party is going to use the power of the presidency and the power of prosecution to go after political opponents in the absence of immunity for criminal prosecution. Okay, so why, that's the only thing he says, by the way, about whether the president should be in office or whether the in-office, out-of-office distinction should matter at all. So then, what do I think? I tend to be fairly moderate relative to a lot of progressive law professors about a lot of cases. I tend to take a pretty middle ground on a lot of these cases. I read this case and my head nearly exploded. So and just from Roberts' opinion, This one, I'm not feeling particularly moderate about. I thought that Roberts' analysis was terrible, like really bad. So why? Well, first of all, the distinction between criminal and civil liability should matter deeply. Why? Because we only have 51 governments. We have 370 million citizens. So for civil liability, it is possible for a president in office or out of office to get harassed by up to 371 million lawsuits. When it's a criminal case, first of all, you have double jeopardy, so you can't be tried more than once for the same crime. Second of all, if you've committed one crime and all 51 governments want to go after you for it, well, first of all, it'll be hard because usually the crime only happened in one state. So only that state has jurisdiction over the crime, and maybe the federal government. So the scope of possible harassment is much narrower in the criminal context than it is in the civil context. Second of all, you have all kinds of constitutional defenses you might be able to bring in a criminal case that you can't bring in a civil case, at least not nearly as easily. State action doctrine. A private citizen can sue you, and you don't get to say, hey, you can't sue me because of the Constitution, because that's a private citizen who's not bound by the Constitution. But if the state comes after you and tries to put you in jail, or the national government does, you can bring a constitutional defense and say, this litigation can't go anywhere. The government is not allowed to come after me for this because I have a constitutional right to have engaged in the conduct I engaged in. So if the president has constitutional authority to violate a statute and has acted within the scope of that permissible authority, he doesn't need immunity. He can just use an affirmative constitutional defense to say, you're not allowed to come after me criminally for this. And the statute that prohibits me from doing this is unconstitutional as applied to me, the President of the United States, right? So when Roberts talks about the Youngstown framework, and he says he repeated in his opinion probably like 50 times the phrase exclusive and preclusive authority. Exclusive and preclusive authority. When the president acts with exclusive and preclusive authority, then he has absolute immunity. Why? He has constitutional power. He doesn't need absolute immunity. He can just argue that a statute that tries to prohibit him from exercising his exclusive and preclusive authority is unconstitutional under Youngstown Category 3. Easy. And Roberts is like, oh yeah, but it takes too long for the litigation to figure that out. We don't want the poor president to have to show up in court and argue his constitutional defense. He's going to have to argue his immunity. He has to actually go in front of a court and say, I'm immune from prosecution for this. Why does the immunity claim, why is that any easier to resolve than the Youngstown Category 3 claim? Especially given the way Roberts went through all of his analysis, it's not going to be any easier. We can talk about that maybe later, but he didn't make it easy to figure out whether or not there's immunity. So it doesn't make any sense to say you need immunity from criminal prosecution when there are so many possible constitutional defenses available to the same criminal prosecution. So this is like a major distinction between the civil liability context and the criminal liability context that Chief Justice Roberts simply did not discuss, at least in the kind of depth that I wish he had. And all of the prior cases that Josh went through at the beginning all had to do with civil liability rather than criminal liability. So this was the first one to bring up this issue of criminal liability or criminal immunity. The other reason that there's a big difference between criminal and civil prosecution, or criminal prosecutions and civil liability, is that there are internal political checks on criminal prosecutions. We're talking about an executive agent going after another executive agent. And they all kind of live in the same universe as one another. Now, I could go sue Donald Trump, and I have no professional, relationship with him. Thank God. But I'm allowed to be so biased. I love debates.
Let it fly.
I don't have to pretend to be neutral in this context. So
Be neutral.
I never pretend to be. Nobody's neutral. If you act neutral, it is absolutely a pretense. Okay, so like I have no, professional affiliation with Donald Trump at all, but Joe Biden does. They're both in the same camp of being presidents, and the people who work in the DOJ who have to go after him have worked under him for some period of time. They're going to wait until something really egregious has happened before they go after a former president of the United States, just out of like kind of professional norms. And so when Roberts talks about this sort of nightmare scenario of political prosecutions after presidents leave office, like maybe in the current environment, we're on the verge of that becoming a reality because things have gotten so bad. But at the same time, this is happening because things have gotten so bad that we actually have a president who has done something so egregious that we need to go after him using the criminal law. This is an extreme case. It's an outlier case. And Chief Justice Roberts treats it as though it's a new normal, despite the fact that it hasn't yet become a new normal. So he's like solving a problem before the problem really exists, and doing so with, I think, a very dangerous instrument. So I don't think he gives enough attention to the real differences between criminal and civil. How long have I been talking? I have no idea.
Only 10 minutes.
Okay, so I have 2 more minutes to talk about the in-office versus out-of-office distinction. Chief Justice Roberts says a lot through the opinion that the president is the only member of the government who is solely in charge of an entire branch of government and needs to have sustained focused attention and be able to act decisively and quickly without fear of possible consequences after he's left office. So this is part of a broad theory of executive power that has been making its way through the Supreme Court for many years, called the unitary executive theory. The theory is that the separation of powers demands that the president specifically be able to act with no supervision or check by Congress or the judiciary, because the president is a unitary branch of government with a single head. That idea of the presidency is one that in a lot of contexts I'm fine with, but in this context I find deeply problematic because he's not in office anymore. He doesn't need sustained focused attention and not to be distracted by criminal prosecutions when he's not actually serving as president of the United States. It doesn't make sense to say, even after you've left, we need to preserve your power to manage the White House effectively and efficiently. I also worry that if you take the unitary executive theory too far, we end up in a kind of quasi-fascistic system in which our executive branch can act with literally no oversight or check. And I just can't think of a crime that I really want my president to be able to commit. I don't understand the logic of saying like, oh, for efficiency's sake, I really want Donald Trump to be able to be a criminal without fear of consequences. Really? Like, efficiency is not the preeminent value of governance. It wasn't when we designed the American system. The purpose of separation of powers was to slow the system down. And the purpose of checks and balances was to prevent a president from becoming so efficient that he could become tyrannical. And part of what made my head explode about this opinion was the number of times that Chief Justice Roberts and Justice Thomas appealed to liberty as a justification for protecting presidential immunity, which is so backwards, I cannot get my head around it. Liberty is preserved by checks and balances, separation of powers, not by absolute power consolidated in any single branch of government. Separation of powers is not really separation of powers. It's checks and balances. It's a system in which the 3 branches fight for power, and that keeps power away from any single person, which is how we're supposed to preserve liberty through separation of powers, not by creating any branch of government that has absolute authority to do anything. So the logic underlying Chief Justice Roberts' opinion, it shocked me. It's not conservative logic. It's not consistent with how constitutional conservatives are supposed to be thinking about the preservation of liberty or presidential power. And I thought John Roberts was a more sincere, less partisan justice than he appears to be in this particular opinion. So I am not on board with this one. And I think it's a much more significant opinion than Josh seems to think it is. There's a lot of hedging in Chief Justice Roberts' opinion around official acts that do not fall into that Youngstown Category 3 block, that are just official acts, but not exclusive of preclusive authority. And so there's a lot of wiggle room. Maybe this opinion is going to get watered down as it continues to get litigated. But as written, it is nonsensical and dangerous.
And bass backwards.
And bass backwards.
I have to think about that one for a second.
You have 5 minutes,
Thank you
sir.
so much. I will do my best in 5 minutes. So first, on the distinction between criminal and civil, yes, there are 51 states, but there are how many counties in the country? Anyone know? You're in the city council?
88 in Ohio.
How many? Can you guys pass criminal ordinances? Can some of your? How about some small county in Alabama makes it a crime to allow invasion of the southern border? Just think about it for a second. There are a lot of local prosecutors that would be happy to indict presidents of both parties. The difference between raising an affirmative defense and immunity is one difference: the interlocutory appeal, right? It wasn't that, of course, you have to litigate it. Robert said, we don't want people having to go all the way to a trial and then appealing for years. We want people to raise right away. This is where Barrett and Roberts disagree. Barrett would let you raise affirmative defense, like Mr. Moncrief said. Robert says, no, raise an immunity defense. It's the same argument. The same argument is presented, just when you get to take your appeal. By the way, the 5 members of the solid majority all served in the executive branch. Who did it? Justice Barrett. This is not a partisan decision. This is a decision from lawyers who served in the executive branch, who served through Iran-Contra, who served through all the other scandals. They know what these investigations are like. They know where they lead. They want to cut them off right away. Again, this is not, Robert's not a partisan. We talked about Obamacare for years. He is not a MAGA judge, my God. He hates Donald Trump, right? Does not want to be in office ever again, but he cares about the presidency sincerely, right? I would bet you anything that Robert's going for Harris. I will bet you that with any dollar in my pocket. Not important. Okay. Now, let's talk about the difference between the president and his subordinates, right? Does the president actually execute the law himself? Actually, he doesn't. He has to take care of the laws are faithfully executed by others. So let's say the president orders a drone strike of someone, and that person gets killed. Let's say it's a U.S. citizen, right? Usually if you order a drone strike to kill a citizen, that's called murder. But when the president does it, that's called foreign policy. Do we really want a U.S. municipality allowing a murder indictment to be brought against the president for issuing a drone strike? I think murder is generally bad, but we need to decide, was this act in the U.S. interest? Relatedly, an example that was raised, let's say that the president orders SEAL Team 6 to go assassinate his rivals, right? Oh my God, no immunity for that, right? What Marine or Navy official would ever actually follow that order? They'd resign. Even if the president's immune, the subordinates are not immune. That's why I think this is not that big of a deal, this decision. In 5 years, we won't be talking about it at all. Trust me, this will be a thing of the past. Because the president must have his subordinates execute, no pun intended, execute the law. So really, we're talking about a fairly narrow range of conduct. Now, in terms of trusting the process, we trust someone else who's president not to prosecute their rival. Oh man, I've been around this block too long. I'm cynical, right? The current president is trying to put the former president in jail, right? Of course, he appointed a special counsel, all these independent apparatuses, but the goal of Jack Smith, I have a brief in this case, is to try to put Donald Trump in prison. To be very, very clear about that. He didn't have to. Garland didn't have to appoint the special counsel. He could just let this run and hopefully the process cleans itself out. Now, I want to make one final point about how much time do I have left?
You have,
Sorry, let's try.
sorry, my phone is
Okay.
loading.
It's okay.
You have still 2 minutes.
Okay, let me make a few final points about this decision. Number one, no one asked the court to overrule Nixon versus Fitzgerald. They could have, they didn't. Okay. Once you accept the position that Roberts does, that criminal has different implications, that criminal is actually worse than civil, right? That there are far many more county prosecutors than there are state prosecutors. This decision looks a little bit different. That when you see that a defense raised affirmatively or defense raises immunity basically looks the same way. The only difference is in locatory appeal. It doesn't look that bad also. And we sort of look at the long tradition of prosecutions going back to Roman times, where people, bring criminal charges against their predecessors. We realize that there is a risk here. And so the majority, again, did not make a risk that's partisan. I think they made a choice of trying to protect the presidency as an institution. I still think there's ample power to hold Donald Trump accountable, and the indictment was rewritten in a way that he probably does pass the court's muster. So again, all the sort of the outrage about this decision, I think, is not for much. I think people need to sort of just take a deep breath, realize that there's an election in about 6 weeks or so that will decide this issue once and for all. But as a matter of constitutional law, this is not an opinion for the ages. It probably forgotten about 5 years or so. Thank you.
Most welcome. And by the way, as a county commissioner, while people differ on what counts as a county or not, all sources agree there are over 3,000 counties in the U.S.
Thank you. Yes, so that's a significant number.
Professor Moncrief.
That's awesome. I was going to guess 3,000 actually,
okay. Yes.
because
I'm sorry.
I knew that there were approximately 3,000 judges in the country. And so I was like, probably a similar number. So yeah, 3,000 counties. All right. So now for a county to go after you, though, you have to have committed a crime in that county. So how many counties is the president going to visit and commit a crime in that county? So yeah, the counties can go after him, but only if he has actually visited them and committed a crime while there. So the counties will have limited power to go after him, unless he actually does go on a crime spree, a literal crime spree. It will be hard for too many governments to be able to actually prosecute him. Mostly it's going to be the national government, which is what it is now. So now Josh brings up drone strikes, and he says we want the president to be able to, go murder people with drones. It's illegal to murder people with drones. I kind of would like to see President Obama brought to trial for having murdered people with drones, because it's illegal. It's stunning to me that we have allowed presidents to flout these legal prohibitions. Torture, also illegal. President Bush, President Obama ordered torture on a number of occasions, and we have just not done anything about it. And I actually think it would be good if we did. So this is, for me, not necessarily a partisan issue either. I think it would be good if all presidents had to think about possible criminal consequences of the orders they give when they were making those orders. I want us to be able to stay safe, and if Congress needs to change the criminal law to empower the president to keep us safe, then so be it. But as long as there is an actual law on the books saying that President Obama and President Bush and President Trump and President Biden are not allowed to execute people with drones, I would like for them not to execute people with drones or face criminal liability when they do. So the concept of the rule of law, the concept of legislative supremacy, the concept of checks and balances, all of those concepts that are supposed to preserve liberty, contra Chief Justice Roberts, all of those doctrines are ill-served by a strong, robust form of presidential immunity, whether it's accomplished through professional courtesy or through constitutional analysis. I would rather see presidents held to account. The idea that the president doesn't actually execute the law, it's the lesser functionaries who do, and they're not going to follow illegal orders because they don't get the same scope of immunity. There's a concept in analysis called the nirvana fallacy. I can never pronounce it correctly the first time because anyway, there's too many A's and they're all pronounced differently. Nirvana fallacy. The nirvana fallacy, that you take a jaundiced view of your opponent and a rosy view of yourself. So I saw in Chief Justice Roberts' opinion and in some of what Josh just said, some real evidence of nirvana fallacy, where you say, if we allow criminal prosecutions, then we're going to have political prosecutions run rampant. I don't trust the Department of Justice at all. They're just going to go after all of their political rivals all the time with these criminal laws, with flimsy criminal arguments. But as long as we give the president immunity, everything will be fine because the president and his functionaries won't commit crimes. Well, why do we think the president and his functionaries are so rosy and wonderful and honest and are not going to commit crimes when we know they do? And then think that the Department of Justice is going to run rampant and engage in all of these political prosecutions when we've seen that happen literally once in American history, and it was for a president who tried to stage a coup. So, we have this extreme example of one political prosecution, and Chief Justice Roberts says, oh, it's going to become the new normal. And Josh says, oh, well, it's happening right now, therefore it's definitely going to happen. Well, this is an extreme outlier case. Maybe this is the only one. Maybe I'm wrong, but if I'm wrong, we can deal with it when when the problem occurs. Whereas the problem of presidents regularly flouting congressional directives and committing crimes seems to be an actual problem that has occurred on a number of occasions in recent memory and that we all know about. So I would rather err on the side of allowing criminal liability for presidents than err on the side of shielding them so absolutely, and then see what happens. And if we end up in a world of rampant political prosecutions, and this isn't just a single outlier case, then we can handle that through reinterpretation of presidential immunity. But this seems like a dangerous precedent to set, and I'm worried about what follows from it. It also, do I have any time left or am I out?
You do. You still have a minute.
Okay, cool. I'm going to spend a minute to just talk about how difficult Chief Justice Roberts' test is for immunity in that Youngstown category 1. When the president acts engages in an official act that's authorized by Congress, but also in so doing commits some kind of crime, Chief Justice Roberts is maybe absolute immunity, maybe just presumptive immunity. We kind of have to decide. And then what counts as an official act versus a private act? That's a very fact-intensive question, and we have to try to figure it out. So he looks at Donald Trump's speech at the Ellipse on January 6th, and he says, well, the president has an official role in speaking to the people, in trying to communicate messages about the law and the integrity of the federal election, but he also was a candidate. And so is it an official act? Is it not an official act? And it's really, this is how we want to try to figure out whether or not a president has immunity for staging a coup, whether or not where's the boundary between his official acts as president and his private act as a candidate. I would rather just say no immunity from criminal prosecution. It's a much simpler rule. It's much more consistent with the history of the United States, with the sort of overarching values of separation of powers that underlie the American Constitution, and I think would create a better world in the short and long term. And then if it messed up, we can always fix it later.
Thank you. Thank you. A round of applause for our debate. And now questions, and I do mean questions, because I know we sometimes want to make comments, but we want to take advantage of the expertise we have with us.
So I want to come back to the SEAL Team 6 scenario. I know a lot of things spilled on it, but at a time when Trump and a lot of the people that he's surrounding himself with are bent on sort of denigrating and weakening democratic institutions, I wonder why we are less concerned about this. It seems like you're relying a lot on the strength of these democratic institutions to bend and blunt some of these more destructive impulses, like the SEAL Team 6 scenario. But if there's success in getting rid of like civil service protections and surrounding the president with loyalists and things of that nature, doesn't that kind of situation concern you more, that they will find someone who will do these things that he asks them to do?
Sure. I don't put much weight in democracy. I don't do it. I want to answer your question candidly. Democratic institutions, if the president wants to appoint people that are loyal to him, that's his job. That's his authority. I am far more worried about prosecutors using the legal process, we call lawfare, to try to hamper the incumbent president, than the incumbent president doing something that's perhaps problematic. There are checks for an unpopular president. There is impeachment, which didn't prove to be all the way, but it actually got more votes than you might expect the last time. Presidents have to stand for office. Again, presidents have to have people who are confirmed by the Senate. He can't just appoint anyone he wants in office. There are different checks built into the Constitution to limit the president's power. I would use those checks and rather use external lawfare approaches, such as criminal charges and civil litigation. Thank you for the question.
Professor Moncrief?
I mean, we've never had a president impeached and removed from office in the entire history of the United States. So I'm not sure how powerful that check is. You know, and it was, Trump came close, but for the shenanigans of Mitch McConnell, he probably could have been removed from office. And did you guys follow this closely enough to know what I'm talking about?
Well, the first one, the second one.
The second,
'Cause
the January 6th.
Well, he was already out of office by that point.
Well, this was the issue. He was not out when the impeachment was voted in the House, and then it was referred to the Senate for trial. And Mitch McConnell goes, "Well, we don't want to hold a trial before the inauguration of Joe Biden because it'll just be distracting and like politically bad. So we're just going to wait until after Joe Biden has been inaugurated. So don't worry, we'll hold our trial just after the inauguration." And the inauguration happens, and Mitch McConnell gets up and says, "Well, we can't hold a trial for an impeachment trial for a president who's no longer in office. The impeachment power only relates to people who are currently holding office, and Donald Trump is not currently holding office." And it's like, dude, really? Can you okay. So
You need the head exploding emoji for this one.
I do.
They didn't make him president of the Senate for nothing.
Oh my God, that man.
I lived in Kentucky for years, so I was under his tutelage. His grace.
You don't want to say tutelage.
That's wrong
With
word.
respect to Mitch McConnell.
Grace. His grace.
Other questions?
I'm just curious, what relevance the fact that Nixon was burned adds to this analysis.
Well, what's curious is that President Ford, when he explained why he pardoned Nixon, he said that Nixon's acceptance of the pardon is almost an admission of guilt. And that was actually how Ford justified the pardon. I'm not sure that Nixon's are quite the same way, but that's how far pardons work. But to Ford's credit, or maybe not his credit, depending how you look at it, he sort of settled what was a very divisive political issue, and he prevented future presidents from going after him. Would President Biden, this is my hypothetical, just maybe a hypothetical. Let's say that we have an election in 6 weeks and it's very close, and say there's disputes in the court. What if Biden says to Trump, "I'll make you a deal. Let's make a deal, right? If you drop all of your appeals, I'll pardon you." Would that be a bribe? Thing of value, very valuable, pardon, in exchange for dropping your legal rights. But, I thought about this one. Biden says, "We'll let Harris be president. I'll pardon you. You don't have to worry about this ever again." The flip side is, by Harris being president, it means that Biden probably won't be indicted. So he's got something too. Also, for his son might also not be indicted further. So there are lots of very funky things that happen with pardons that I would not want to criminalize. Right? In other words, if Biden made that offer, could he then be indicted for an attempted bribe? Not to answer your question at all, but maybe I did.
You got it backward though. The pardon would be the official act. The thing of value would be the dropping of the litigation. The pardon's not the thing of value.
No. Well, for Trump it is. It's quite valuable.
No, I get it. It's a valuable official act. But the thing of value statutorily would have to be the non-official act.
I want to state for the record that my fellow Duke Law alum Richard Nixon was an outstanding president, and this slander will not be tolerated. But we have time for one more question. One more question.
One more. Yes, sir.
So I've heard a statistic, it's been a while, but it's the average American commits 3 felonies a day. Assuming that this is true, and that the presidents are also committing these 3 felonies a day, would that not give a very large amount of crimes that they could potentially be charged on, and is this a concern at all?
Yes.
Yeah, I mean, I think it's a minor concern. I think if we get to the point where prosecutors really do dig up minor felonies or like passing felonies or things that you and I do on a regular basis and throw them at former presidents just to try to undermine them politically or try to undermine their party politically, then I will reevaluate my assessment of this opinion. But that's not the world we live in. We live in the world in which all of our former presidents have committed gross felonies, assassinations and torture and various other things that I'm not cool with, and have not been prosecuted or even held to account at all. So we live in the opposite extreme. We're seeing one prosecution of one president who literally tried to stage a coup, and all of a sudden it's like, oh my God, political prosecutions. No, that's not what this is. This is a rational reaction to an extreme event to try to preserve American democracy. and you're acting as though it's opening the floodgates of political prosecutions, I'll wait until the floodgates have cracked open a bit more before I want immunity as a solution, especially the kind of absolute immunity that John Roberts created.
I'll make one last point. In Clinton v. Jones, the question was, could the sitting president be sued? And Justice Stevens said, well, this has never happened before. There are not many of these lawsuits. We're not really worried about it. And Trump has sued civilly almost consistently through his administration for emoluments and other things. I think if 3 felonies today will not be hard for some county or some government somewhere to find reasons to indict a sitting president on who knows what, or former president. And that fear, I think, does have a chilling effect.
On that note, thank you.
I never thought I'd be defending Obama, but I guess I am.